Hello, everybody, and welcome to the first lesson in a series on the subject of international humanitarian law. In this video specifically, we're going to take an introduction to the subject. We're going to think about what international humanitarian law is, what are some of the legal sources associated with the study of international humanitarian law. We will think about what international humanitarian law is not, which is one of those things that really can trip a lot of students up thinking about really what is the scope of application of international humanitarian law. When are we having conversations about IHL, and then when are we having conversations about another area of international law? And then we will finish by thinking about the scope of this series of lessons, looking at the kind of things that we're going to be studying over the course of the next 40 or so videos on this particular topic. So, this is essentially what we are going to be doing. Like I said, we're talking about international humanitarian law, talking about its sources, talking about its basic principles, because even though this is only an introduction lesson, I will be providing with you some basic principles of international humanitarian law that will be the framework and will be the guidance for us for thinking about the next few videos on this topic. Things like the principle of humanity and distinction and proportionality, all of these very core and foundational ideas within the subject of IHL. I should make it very clear at the outset that instead of saying the mouthful, which is international humanitarian law, every single time, I will often be abbreviating to IHL. If you see IHL, or if you see the phrase law of armed conflict or LOAC, I'm basically using those words interchangeably. We're talking about IHL, we're talking about international humanitarian law. So, as a basic introduction, then, international humanitarian law is a branch of public international law that is designed to regulate the conduct of hostilities during an armed conflict. We're talking about the laws of war, but we're talking specifically about the laws in war, okay? More broadly, what international humanitarian law can do, and what IHL does, is it protects persons not participating in hostilities. So, people like civilians, those people who are not involved in the direct participation of hostilities, they are unable to be targeted, for example, in IHL. Same with medical personnel. People who may be working in terms of medical, in medical ways associated with the conflict. So people like Red Cross, people like who work on the front lines in sort of field hospitals and these different kinds of things that are treating people who have been injured or who have sustained injuries as the result of armed conflict, as the result of war that has taken place. Humanitarian workers as well are getting humanitarian supplies to conflict zones, using humanitarian individuals and to provide aid to civilians, to provide aid to medical personnel, to provide aid to various different parts of the world that is affected by conflict in some way. And then those soldiers, people who maybe were participating in armed conflict, who maybe are no longer able to participate in armed conflict. So, if you are wounded or sick, for example, what rules apply to you? Or if you are a prisoner of war, if you have surrendered and you are now therefore in the hands of the enemy combatants, what kind of things should be expected of those enemy combatants with relation to how they treat you personally? That is also important as a rule and as a way of protecting people who are not participating in hostilities. IHL is also concerned in things like limiting the means and methods of warfare to prevent unnecessary suffering. Essentially, when we think about IHL, if we just thought about it from that first perspective, thinking about people not participating, that does not imply that for all those who are participating in armed conflict, that it's fair game, that you can basically do anything you want to that group of people, and it doesn't matter how sadistic, how horrific, how brutal the conflict gets. In fact, there are very strict rules about the means and methods of warfare, the ways in which we can limit the types of weapons that are used, the types of tactics that are used in order to prevent unnecessary suffering. And so when we think about this, there's the interesting question. If this is the law of armed conflict, why don't we call this series the law of armed conflict or the laws of war or whatever like that? Why are we calling it international humanitarian law? Well, like I said, it is sometimes called LOAC or the law of armed conflict, but it recognizes, IHL recognizes as a concept that war itself, that armed conflict is cruel and it is inhuman. It is humanity at its worst. If we think about some of the wars of the past, thinking about the Second World War, thinking about the war in Vietnam, thinking about some of the conflicts that may be taking place right now at the time at which we are recording, war is cruel, war is inhuman, war is horrific. And so the underlying rationale for IHL is to instill, insofar as could possibly be instilled, a sense of humanity in the fighting, trying to maintain a sense of humanity insofar as is possible in a time period in which there is just such cruelty and inhumanity, trying to find this kind of this kernel of humanity in there. And it's also important for post-war reconciliation. It's also important to basically have this semblance of humanity that is present for when the fighting actually stops, when the war actually ends, and people have to then go back to living with each other and go back to the sort of a post-war settlement and a world in which that war has taken place. The kind of trauma, the kind of post-war problems, the loss of life, the loss of economic stability, the loss of maybe humanitarian resources that is necessary to survive. So I guess you could say that that is a basic overview of what IHL fundamentally is. It's also important to realize what IHL fundamentally is not. Notice here that within this rationale of international humanitarian law that I've been speaking about, there is a fundamental assumption that is sort of permeating all of our conversations, and it will permeate our entire conversation about this subject for the rest of these lessons. And this is a very, very important assumption. It is the assumption that war exists as a concept. Okay. Now, IHL itself, the body of law that is international humanitarian law, has nothing to say about whether or not a particular war is itself lawful or unlawful. The war as a concept being lawful or unlawful. Okay. For example, when Adolf Hitler on the 1st of September 1939 invades Poland and starts the Second World War, on an account of the international law that exists today, that war would be unlawful. There would be no lawful justification for that war. But IHL doesn't have anything to say about that. IHL is concerned specifically with the conduct that is taking place within the parameters of that war. So it almost views war as a state of being, as a state of either we exist in a war or we don't exist in a war. If there is no war, then there is no application of IHL. If there is a war, then IHL applies, and it is concerning the specific contents of that conflict. We'll get to what the difference between different types of armed conflict are, and the sort of the sort of when an armed conflict is triggered in future videos. But that's an important point to raise. It is the law which applies after then it has been established that an armed conflict exists. And this is a very classic distinction that exists. And it's a distinction between two areas of international law. The first is what we call the jus ad bellum. The jus ad bellum is the law on the resort to war, the international law on the use of armed force. This is primarily governed by the UN Charter, and it is primarily something that is not going to be focused on in this series of lessons. It's a completely different area of law. This is not to say that there isn't some interactions. There might be some conceptual interactions between the two. And of course, it's concerning the use of armed force. So there is some kind of interconnections between these two areas, but they are still fundamentally different areas of law. The second area is IHL, or sometimes described as the jus in bellum. The jus in bello, sorry, the war, the law in war, the law regulating hostilities once the war has been established. And so you have a very interesting paradigm. You can have lawful conduct in unlawful wars, as well as unlawful conduct in lawful wars. So, for example, the invasion of Iraq in 2003 by US and coalition forces is on account of the jus ad bellum, on account of the international law on the use of force. Most scholars, the vast majority of scholars, will conclude that that was an unlawful war. It was an illegal war. But that doesn't mean that, therefore, every single piece of conduct that we could identify in that war was unlawful from the perspective of IHL, soldiers engaging in conflict and following rules of engagement and following the sort of IHL practices. They were lawful acts, even if it was done in an unlawful war. By contrast, you can have lawful wars. For example, the Allies' defense of the European world in the Second World War. That would be on account of a sort of modern conflict. That would be a lawful self-defense under the UN Charter. Of course, none of that existed at the time, but let's just use that for a hypothetical. In that context, there were war crimes that had been committed by Allied soldiers during that conflict. And so you have a lawful response to war, you have a lawful self defense, but you can have unlawful actions in the sense that they violate IHL. So make sure you always keep these two concepts distinct in your mind when thinking about this area of law. So, international humanitarian law derives itself from a number of different sources, just like basically any area of international law that we study. So, for example, and just along the same kind of lines as ordinary public international law, one of the main areas of international humanitarian law, one of the main sources, are treaties. The treaties that have been developed, a lot of them developed after the end of the Second World War, after the horrors and the destruction that was caused by the Second World War. There was this real impetus from the entire international community, from the newly founded United Nations, to really start codifying more strategically and more importantly some of the rules of IHL, especially also taking into account some of the technological changes that existed as the result of the Second World War. There's a lot of debate about aerial bombardment, for example, and there were sort of negotiations and there were back and forths and sort of summits that took place prior to the Second World War, but nothing was ever written down and formalized in a treaty before the Second World War. When we think about IHL and we think about the treaties that are associated with IHL, one of the first places that you will be thinking about would be the Geneva Conventions, the four Geneva Conventions of 1949, as well as the protocols which were additional to the Geneva Conventions that were established in 1977. That's where a lot of our treaty law is going to come from when we think about some of these basic principles of international humanitarian law. Make sure if you are studying this area of law, make sure you have these basically the Red Cross website with access to these two groups of treaties. But there are additional treaties. There are Hague Conventions that existed prior to the Second World War. There are also conventions like the Conventional Weapons Convention, the CCW. You have things like the St. Petersburg Declaration that's going to be very important when we think about things like the Martins Clause. There's also a number of different arms controls treaties on things like cluster munitions and things like white phosphorus. You have ICL treaties, so treaties that concern international criminal law and concern the areas in which there is an interconnection between international criminal law and international humanitarian law, specifically with regards to things like war crimes within the Rome Statute. That's a very important area that is identified by treaties. And also, like I said, the Hague Conventions as well. In terms of customary international law, one of the most important resources that you will find very valuable as a student of IHL is the ICRC's study on customary rules of international humanitarian law. Just search that and you'll find it on Google. It has a number of different rules. And the attempt of, and essentially what the ICRC was trying to do here is try to codify what the position of customary international law was with regards to the rules of IHL at the time at which it was created. It's updated some new rules as well, but of course, as we know from people who have studied public international law already, if you've watched our lessons on public international law already, you will know that customary international law is not as easy to identify as a treaty, for example. It involves thinking about consistent state practice, as well as this idea that the state practice is being conducted with the view that they are basically following an obligation, this idea of opinio juris. And so identifying customary international law can be a little bit difficult, and so the ICRC study on IHL is and customary IHL is a very, very valuable resource. You could also point to soft law and manuals. So the San Remo manual is very, very important for thinking about the law of blockade, and laws relating to naval warfare as well. As well as the state law of war manuals. So, for example, the UK's Ministry of Defence law of war manual, or the US law of war manual, or any other manual that is basically handed out to soldiers and to military generals and commanders to basically set out what the domestic legal position is on these particular areas of international humanitarian law in order to ensure that there is compliance with these basic rules of the Geneva Conventions. Of course, there will also be things like the interrelationship with other legal fields. So, there is a huge debate that has been going on for the past 10 or so years, probably even a bit longer, about the interrelationship that exists between international humanitarian law and international human rights law. To what extent do we say that international human rights law provides additional over the top, if you will, or additional protections on the rights of people living in warfare than that of IHL? A very interesting debate that is to be had is to what extent is international human rights law engaged when people are living under belligerent occupation, when they are living in a state of occupation? To what extent is it just IHL that is engaged, or to what extent is it both IHL and international human rights law? And if that is the case, what is the kind of mechanism and relationship that exists between those two areas of law in that particular circumstance? Similarly, when thinking about things like war crimes, and you could also apply things like the law of genocide to this as well, international criminal law interacts with international humanitarian law in various different ways too. We'll get to this in future lessons, as well as things like refugee law, the definition of a refugee, thinking about the Refugee Convention. When populations are fleeing conflict zones, this means that there is a direct interconnection between the law as it applies to armed conflict, the IHL, and the refugees that are created as the result of the conflict that is being regulated. So that also has to be thought of and understood as a very important part of this area to study as well. Finally, before we look at the scope of this series of lessons, I just want to very quickly go through the core legal principles that are researched in IHL. These are essentially the principles that guide the interpretation and application of IHL. And it is these basic principles that are fundamental to all areas of international humanitarian law. And so if you just have these four principles drilled into your head and drilled into your basic understanding, then you won't go far wrong when thinking about IHL. The first principle is the principle of distinction. This is the principle that we have to distinguish at all times in armed conflict the delineation between what are legitimate military objects and objectives and what are not military objectives. This is often a distinction between the combatant and the non combatant. This includes not only people, i.e., combatants, people who are actually actively engaged in hostilities, and non combatants, but also objects, civilian objects, medical objects. These are all things that can never, in any regards, be targeted in international humanitarian law. There are methods and ways in which a civilian will lose their status as being a non-combatant in IHL if they start to directly engage in hostilities, for example, or a civilian object like a building, for example, might be ordinarily a civilian building, but if it then is starting to be engaged with by a combatant military in order to be used for military purposes, then it can also have the effect of losing its status. There is also the tricky area of the law concerning what we call dual use objects, objects that have both military and civilian applications. To what extent does the law apply there? But even though there are some gray areas, and even though there are some tricky little areas that the law is doesn't apply as neatly, the fundamental principle of distinction is always applied and is always applicable in IHL. The next major principle is this idea of proportionality. Even when attacks against military objectives are sought out, so let's assume we've dealt with the distinction issue, we've distinguished between a legitimate target and an illegitimate target. It doesn't mean that you can just attack that military target straight away without any kind of additional considerations. Because what this principle tells us is that even attacks against military objectives must not cause excessive civilian harm relative to the military advantage that is anticipated. So there is a very clear rule here that says that that recognizes that there might be circumstances in which civilians might be injured, or civilian objects might be destroyed, or might be damaged in the process of conducting armed conflict, especially in these kind of modern armed conflicts where there is an increasing amount of urban warfare that is taking place. That is a sort of relatively new phenomenon in the sort of history of warfare compared to wars of centuries ago. There's likely that civilians will get injured in a strike that is issued, even if that strike is directly targeting a legitimate military target. And so in IHL, that is acceptable so long as it is proportionate, as long as there is no excessive civilian harm relative to the military advantage anticipated. There is an additional targeting consideration that needs to be made as well when thinking about this. This is the idea of precautions, making sure that you have taken all feasible precautions to reduce, insofar as possible, the incidental loss of harm to a civilian or civilian objects as well. We'll get to that in future lessons when we look at targeting and the rules of targeting. There is also the principle of necessity. Force must be limited to what is necessary to achieve a lawful military aim. There cannot be, and there must not be, the use of unnecessary suffering. There must be the avoidance of unnecessary suffering. This is to try and limit the hostilities of armed conflict, to try and limit it insofar as possible so it only achieves the lawful military aim and doesn't go over the top. If there is, for example, a building that is a legitimate target and it could, by all circumstances, be destroyed with a single strike, okay, then the principle of necessity will basically dictate that you would not use excessive force to try and destroy that building, and in the process you end up killing a load of civilians and all this different kind of things as well. Obviously, that engages the other principles of proportionality and precautions, but essentially the point here is that we are not trying to cause unnecessary suffering. War itself, armed conflict itself, is evil enough as it is. It is horrific enough as it is. There is not this sort of desire, or there should not be this desire on the part of states and on the part of militaries to engage in unnecessary suffering. And then finally, the principle of humanity. This idea links quite closely with the principle of necessity. This idea that we should be taking into consideration the basic principle of humanity, thinking quite clearly that even in armed conflict, when violence and force may itself be lawful, human suffering must be minimized, and also that human dignity must be respected. That's why we're talking about international humanitarian law. It requires that all persons that are affected by war be treated humanely in all circumstances, and is protected from any kind of unnecessary harm. This is one of those principles that is imbued and permeates every single aspect of the law of international humanitarian law of IHL. So, with all this in mind, then let's think about what we're going to be studying over the next 40 or so lessons. I can actually scroll down and tell you exactly how many lessons it is. It's 46, exactly 46 lessons. Well, I'm going to read out everything on the screen here, by the way, because I do recognize that some of this is quite small, but that's just to try and fit this entire sort of spider diagram on the screen. The first major topic is going to be concerning the foundations of international humanitarian law. This involves looking at the basic introduction that we've done here, but also thinking about the ways in which international humanitarian law interact with other fields. So, what are the interactions between this area of law and human rights law, or this area of law and the jus ad bellum, or this area of law and international criminal law? You could add other ones. There could be others, like, for example, the interaction between IHL and environmental law, international environmental law, because, of course, when you destroy an environment in war, that obviously has a climate catastrophe issues associated with it. We will then spend a bit more time thinking about the sources of IHL. We've touched on that here, but we'll go into it in more detail as its own specific and important foundational lesson before thinking about the history of IHL, looking at how it's developed, looking at how some of these treaties have developed over time, and then thinking about those core principles: the principle of distinction, the principle of proportionality, the principle of precautions that we haven't touched on here, but we will do in future lessons, as well as the principle of military necessity and humanity. That's the first section on this series. The next section will be concerning ourselves with the issue of the classification of conflict. So we're going to be thinking about the distinction that is made between the international armed conflict and something that we call a non-international armed conflict, or a NIAC. Within the framework of international armed conflicts, there are subjects such as the issue of belligerent occupation and sort of the law associated with occupation law more broadly. Within the context of non-international armed conflicts, there are concerns about and questions about the scope of hostilities in terms of the sort of severity of force that is necessary to trigger the instigation of a non-international armed conflict. To what extent does civil unrest that is internal and domestic to a particular state go from simple civil unrest or a riot to a civil war, to an armed conflict? And we will think about that. We'll think about the Tadic case that establishes that, and we'll think about some of the rules associated therein. And we will also think about the scope of application. When does IHL apply? We've answered that question, that it applies when there's an armed conflict, but when does an armed conflict begin? That has a different question depending on whether or not we're talking about an international armed conflict or a non-international armed conflict. But also, when does an armed conflict end? To what extent and for how long do there have to be a cessation of hostilities for there to be no more armed conflict? And we can sort of identify some case studies where you have sort of spurious examples of countries that have sort of 2 or 3 days of fighting each other, then they stop for a couple of months and they have another few days of fighting each other. To what extent did that represent two separate international armed conflicts, or one continuous international armed conflict with a sort of period of relative cessation of hostilities in between? To what extent can we think about that in that kind of framework? We will also think about the interaction with the jus ad bellum, because of course, the jus ad bellum is heavily engaged when we think about the scope of application of IHL, because we're essentially asking the question of when a war begins and when a war ends, which does concern itself a little bit with jus ad bellum kind of questions. Topic number 3 will be concerning the issue of the protections of persons. The protections of persons concerns the protections of civilians against indiscriminate attack. We'll be looking at things like the law of siege and siege operations, which of course naturally and necessarily engages with civilians and the support for civilians. There's some very interesting law on this particular topic, and there's some, let's be honest, unresolved issues associated with this topic. We will think about the law relating also to civilian displacement when civilians are moved out of a particular area, and what the law should apply to them. We will think about combatants and the treatment of prisoners of war. We will think about the detention, the concept of detention, detaining an individual within the confines of a non-international armed conflict. That's a relatively interesting area that is also quite new. Thinking about the wounded, the sick, and the shipwrecked, before thinking about the protection of medical services, of hospitals, medical transports, as well as humanitarian relief operations and the use of protective emblems in war as well. Topic number 5, I've written here on my notes that this is weapons law, but we could can describe this as the sort of means and methods of warfare. Weapons law itself concerns the type of weapons that are allowed and the type of weapons that aren't allowed. So we will spend some time thinking about biological and chemical weapons. We will spend some time talking about anti-personnel landmines, cluster munitions, blinding laser weapons, incendiary weapons, before thinking about the law of targeting, the law of targeting concerning the rules associated with when a lawful strike is conducted and when it is not conducted. So these are the kinds of things we'll talk about with regards to targeting rules, precautions in attack and in defense, the proportionality assessments, the idea of the ways in which this actually practically works from the context and the confines of an actual military operation, thinking about things like kill chains and thinking about the kind of ways in which decisions are made with regards to launching and operating strikes and the kind of IHL considerations that need to be taken into account with regard to that. And then we will think about implementation and enforcement in the next topic, in topic number 5. This concerns state responsibility for compliance with IHL, the law relating to individual criminal responsibility, the idea of the law of war crimes, what is a war crime, and how a war crime is defined in IHL. As well as compliance mechanisms, the role of the International Red Cross, for example, the role of UN mechanisms in compliance, as well as domestic implementation of IHL as well. And then finally, we will think about some of the modern contemporary challenges. We will think about, for example, the impact of the law as it concerns non state armed groups, what kind of tricky international legal considerations can be used there, the ways in which there is the interaction between international humanitarian law and counterterrorism. We will think about the law of cyber operations, a very new area of law that is very, very important. An even more new area of law is probably the use of drones and autonomous weapons systems. Within this context, I'm probably going to actually add an additional video or at least an additional context and confines, which is the use of AI and use of generative AI in making targeting decisions, which, if you've been watching the news in the last few weeks, has raised another interesting question about the diffusion of responsibility for making targeting decisions and using artificial intelligence in that particular regard. But it's not too dissimilar to autonomous weapon systems or drones in that regard either. We will think about information operations as well as urban warfare and the challenges that are sort of faced by the idea of urban warfare and things like human shielding, the co-location with civilian objects, and all those different kinds of things as well. So this is the scope of this series of lessons, and it will be done in about 46 videos. In terms of citations and further reading and all these different kinds of things, basically any of the textbooks that you see here are very, very important guides on international humanitarian law. My favorite is Marco Sassuli's International Humanitarian Law textbook, and there's actually a new edition from 2021 or 2022, I believe, on that you could get and pick up at anywhere useful. We will also be engaging with online blog posts that discuss IHL and articles as well, and I'll sort of cite them on the screen as and when they are used and when they are engaged in the video. We'll also try and engage as much as humanly possible in actual real world examples. There are plenty of real world examples that we can identify. So I'm not going to shy away from real world examples, even very, very recent examples when discussing the legal implications. I'll try and do so with as much sort of neutrality and a lack of bias as much as humanly possible. Of course, there'll be some instances and some examples where the correct answer of maybe the lawfulness of a particular decision is obvious. But it's important that we don't just understand and teach and think about IHL from a quite distant approach, just thinking about it as a bunch of laws and rules and things that are written down. These are things that actually affect people in day-to-day life. And so it's important that we actually think about those people and think about the application to actual case studies as well. So bear that in mind when we think about this area of law. I hope everybody's enjoyed this introductory video, and I'll see everybody in the next lesson when it next comes out. Like I said, we'll talk about the foundations of international humanitarian law in the next few videos, and think about some other basic principles and some other basic foundational stuff there. So see everybody in the next video.